Alrighty. Would on-call compensation be necessary if you call an employee prior to their shift to notify them that they are needed to come in or they are no longer needed to come in? Yeah, if they're not scheduled, yes. Do you want to explain your question a little bit deeper, Delmy?
Yeah, I was just a little bit confused. The hotel industry is a little bit new to me, so it's kind of the on-call and all the split shift thing is fairly new. So I was a little bit confused if they're not scheduled on the schedule, but they're on call, and we're not requiring them to come in. We just call them to see if they can come in. If they say no, and then the supervisor would move to the next person on the list, would we still be responsible for paying the on-call compensation for it? I don't know if that makes sense.
No, that's a completely different question. Yeah. So they're not really on call, right? Because in other words, they can go anywhere they want to, do anything they want to. You can call them, they can tell you, no, I can't come in. I've been at a barbecue drinking all afternoon, and that's fine. And their supervisor goes to the next person.
Okay. So then I guess if they are on call, but we call them prior to their shift starting to let them know that they don't need to come in, then would we still be responsible for paying the compensation?
Well, if they're on call, you have to pay them while they're on call. I think, unless I'm misunderstanding the job, let's go into the book and let's look at on call. So there's different kinds of situations where you have to pay people. And what I'm thinking of right now is the kind of job where they have to be ready and available to start work when you call them. So in that case, they can't leave their home. Can't. Go ahead.
Sorry, maybe this example will help. When I worked in retail, we would schedule somebody possibly from 5 to 9, but we would actually have on the schedule that they were on call from 3 to 5.
Yeah, so you would pay them from 3 to 5.
Correct.
Okay.
Okay.
So but the thing is, the difference is for Delmy is and this is so, in compensation, the dirt is in the details. You said that if we call them and they don't come in, you roll over to the next person.
Right.
Then they're not really on call. And so you don't have to pay them. Does that make sense?
Yeah.
But if you told them that they were on call from 3 to 5, and that if you called them, they had to come in, then they are on call and you have to pay them for the time that they're not. So the legal term is when the employer suffers the employee. How does that go? Suffers the employee to work or something. In other words, they're under your direction. And most honestly, my husband was a line worker for Edison. And so they had a call list. A call list is different than being on call. And the reason why is most of those guys are heavy drinkers. And so they would call them and they'd be like, nope, I've been drinking beer all afternoon. I'm not going to go play with electricity tonight. So, and then there were other people who loved to work. And they liked the overtime, and they were just waiting to get those calls. And so it was really interesting. You had the list had to be done in a very particular order so that the most senior people got the first opportunity to work the overtime. So if they wanted to work, they didn't get drunk, they didn't go to Disneyland, they just stayed home and hung around the house all day, because they could usually predict when they were going to be having additional work. and then they'd get called. Now, so I hope, do you feel comfortable with your answer? You don't have to pay them unless you actually control what they're doing.
Yeah, it clarifies it. I think I was just a little bit confused with, if we have them on call, but if we roll it over to the next person, then it's fine if they're not able to come in.
Yeah. Yep. And I love that example of, well, you're on call from 3 to 5. Then that's clear. You're on call and you're going to be paid for it. Doesn't have to be their regular rate of pay. It can be minimum wage. It can be a different rate of pay. But you still have to compensate them for the time that they're standing around waiting to get called. All right. Here's another good question. SB 358. Page 14, California Labor Code Section 42.3 prohibits employers from asking applicants about their salary histories. On an employment application, can there be a section which asks for starting and ending salary, or is this something we are no longer allowed to have on applications? Say bye-bye to the question. We may no longer put them on applications. We may not at any time ask them about their past salary. We may offer them a salary. They can tell us, nope, I don't like it. It's too low. We can even tell them up front, well, this is what the job pays. But we cannot ask what their previous salary was. Who knows why?
Is it because of fair wages?
You got it.
What was the answer?
Yeah. Historically, who was paid the least amount of money?
Me.
It just felt that way. So historically, women and minorities were paid the least amount of money, just the way it was. And I honestly, I did it myself. I would look at people's wages and I go, oh, yeah, I can get this person for $30,000 a year when the job is worth $60,000 a year. And that person only made $30,000 a year because they were a woman in most cases. And women have undervalued themselves for years. And there's a lot of reasons for it. So now what the state of California is saying is, look, a job has a value, all right? And the value is from $30,000 to $45,000. When you interview a person, you look at the person's qualifications, what they bring to the table, and you offer them the job within that range, regardless of what their past history was. Makes total sense if you just look at it from a black and white perspective. I've been writing compensation plans for years, and unions have run their organizations based on that same union concept, same compensation concept. Lots of manufacturing companies have created compensation plans that allowed for people to grow in their jobs financially by learning more skills and all that kind of stuff. So it's really a much better way to run your business is to have a good, solid compensation plan and not worry so much about what somebody used to make.
I'm sorry, I didn't hear what the reason was at the very beginning of the discussion.
The fair wage law is, and the ban the box law is because historically women and minorities and people people with disabilities have been paid less than men, period. Okay. And so one of the ways that we systemically were able to continue that type of discrimination was because They would come in and say, well, I made 30,000 at my last job. So I've got a job opening that pays 60,000. I'm like, wow, they'd be thrilled to death with a 20% increase. So, hey, I'll only pay them 36,000. And that's the way a lot of people used to hire.
Okay.
Now they can't ask that question. So if you go in for a job interview and they ask you to put your last wages on there, don't. That's against the law.
But I thought the book also said with some, I don't remember which unit it was in. It might have been this one, but with disabled, that you can, that was a wage exception.
It depends. So it's a wage exception if you go through an agency that hires people with disabilities. So it doesn't apply to all jobs. It doesn't apply to all disabilities.
Okay.
So for example, back when in the sewing industry, we used to hire like an agency who would bring in sewing machine operators, usually about 15, and they had like a supervisor who reported to our plant manager, and the employees were actually employed and paid for by some type of government funding. And so the company would pay them, back then minimum wage was like $5 an hour, I think, but the company would pay $3.25 an hour, and then the government would pay $3.25 an hour. The employee would actually get $6.50 an hour. No, that's not true. The employee would actually get the minimum wage part of it, and the agency would get, part of it for funding and that kind of thing. So there's a whole bunch of different ways. Now, I also have we have a client that works, that we do training for. They have a company where they have a lot of kids who have autism and, different types of brain injuries and, just a whole bunch of stuff, a whole bunch of different types of stuff. And they hire these kids to do like piecework. And they pay them piece rate, and they pay them very little. And it really kind of bothers me a lot the way it works, but it's perfectly legal. They do pay for their housing, their utilities, and their food. And then they get a small amount, like $20 a week for expenses. So that's perfectly legal, but not for a human resources manager job. You can't go out and apply for a human resources manager job that you're completely qualified, and just because you have arthritis in your feet and you're disabled and you have to park in a disabled parking lot, can they discriminate against you? So it has to be under certain conditions. It's not at any time, anywhere, under any conditions.
Okay.
All right.
Thank you.
You're welcome. Is there any wage and hour compliance for seasonal employees? Delmy, explain that question a little bit better.
I was just wondering if there was anything that we had to comply with seasonal employees. I know, like with the ACA, we have to comply and go back the 12 months and kind of see, if they qualify under the full-time or the part-time for hours. I know it impacts their vacation accruals. And I was just wondering if there was anything with like wage and hour or anything that I'm overlooking for seasonal employees.
I think I'm going to let me see. Who do we have this in staffing? Is that Colleen? Yeah, Colleen, can you address this question? Oh, she had to leave. I forgot. Sorry. Okay. No, she's there. I think she's still there. Well, yes, she doesn't want to address that question. No, I'm just kidding. Okay. Huh?
They would get sick time if they meet the 30 hours.
Yeah. So basically, they have to all wage and hour rules apply to seasonal employees. They work overtime, they get paid overtime. They work sick time, they get sick time. There's no difference whether you're classified as seasonal or part-time or full-time. You're still an employee, so.
So if your seasonal person was to the meeting, the only thing they would get additional would be paid sick time.
Yeah.
So if you're hiring them for holidays,
Make sure they only work 29 days.
they work 29 and a half days.
Because they'll call in sick on the 31st day. I don't know. Okay. Does that answer your question, Delmy?
Yeah, I just didn't know if there was something different because I know that it would impact their sick time as well because we would have to, from the time that they termed to the time they rehired, as long as they were hired within that year, rehired within the same year, then their sick time balance would roll back over.
Yeah.
So I just didn't know if there was something else that I'm not thinking of that would be impactful to a seasonal employee.
I don't think so.
Potentially benefits, but it depends on how you write your policy of when they're eligible for benefits.
You know what I'm thinking of is FMLA. No, I mean, it would be the
No,
same.
because they wouldn't have enough hours.
Well, that's what I'm saying. If you have a seasonal employee who works 1,050 hours, they would be eligible, but still, that's still no different than anybody else, right?
Yeah, you're right.
Yeah.
It's still the same qualifications.
Yeah. All righty. Page 9, functional area number 1, compensation, wage, and hour. Deductions from exempt employees' pay under California rules states that the general rule, both under federal and state law, is that an exempt employee must be paid their full week salary for any work week in which any work is performed, regardless of the number of days or hours. This seems to be contradicted under vacation and personal time. My question is, if an exempt employee has exhausted either their vacation time or sick leave time and is out for, let's say, 3 days in a 5-day work week, but works 2 days out of the 5, must the employer pay the exempt employee a full week's salary? So I love this question because I get to enlighten you. Kathy, you can help me enlighten her. When we, in HR, when we get this, we get suddenly a lot of things change for us. It's like there's this whole new, oh, I get it. It's a world of understanding that I didn't get 2 seconds ago. Now I get it. Okay. Vacation is not the same as salary. When you pay someone their vacation pay or their PTO, you are not deducting from their wages. They're still getting their full week's salary. So if you give them 3 days vacation pay, you're simply allocating it to vacation rather than to their week's pay. So you're still going to give them a full week's pay. You're simply going to allocate 3 of those days to vacation and the other 3 to their salary. Does that make sense?
Okay, so may I elaborate?
Please.
I'm very confused on this one. Okay, so what if an exempt employee is out 3 days, but they don't have any vacation, they don't have any sick, but they work 2 days out of that week, like physically work? Do we pay them the full week?
Yes.
I thought so. Okay, so as long as they work anytime during that work week, they're paid the full week.
Yep. The
Wow.
only exception to that is there's a few exceptions. Does anybody know what they are?
Initial and final week of work.
Okay, say that again.
Your initial week of work and your final week of work.
Correct. Correctamundo. Yeah. So when they, if you hire them and they start on Wednesday, you only pay them for Wednesday, Thursday, Friday. And then if they quit or you let them go on Tuesday and you only have to pay them through Tuesday. Most of us pay them through the end of the week. I will say that, but technically you don't have to. There's another way. What's that? When it's their idea. So they're out on vacation, they're in Hawaii, they signed up for a week off, they are gonna go on a snorkeling trip, and they just want an additional day off where they don't have to do any work, they don't call in, they don't read any email, they're just taking the day off and they're gonna spend it underwater. They can shoot you an email and say, I won't be back until Tuesday and I'll happily take the day unpaid. And that's fine. Kathy, can you add anything to that one?
Nope, that pretty much covers it. I mean, but preface that with saying, chances are they're never going to send you that email saying, hey, I'll take it without pay.
That's right. That's true. Pretty much they're just not going to show up or they're going to read an email and say, okay, I work.
They're going to say, I just sent you that email. I was working.
Yeah. All right. Does that answer your question, Catherine?
Yes, thank you very much.
You're welcome. I think that, I went for years without understanding this. I really did. And then one day it was like a light went on. Like, oh, okay, they're still getting paid for the week. We're just allocating it to different areas. All right, Aleida Martinez. Sometimes the burden of proof is on the employee and others it is on the employer. For instance, the employee has the burden of proof for harassment claims and the employer has to prove exempt status. Is there a formula to remember other cases? So I wrote to her and I was a little bit surprised. The burden of proof is almost always on the employer in any employment law cases. All right. For example, if an employee says sexual harassment occurred, it did until the employer proves it didn't through a proper investigation. It's the same with discrimination. The only proof the employee would have to show is that they're covered under California protected category and that the organization took some adverse action on them because of their protected category. The employer would have to prove they didn't do that. So it's different in criminal. So, okay, burden of proof means the obligation to prove one's assertion. And in a criminal case, the burden of proof of proving the defendant's guilt is on the prosecution. So they must establish the fact beyond a reasonable doubt that the person did it. In civil cases, the plaintiff, and the plaintiff is the complaining person, okay, has the burden of proof that their case by a preponderance of, so if you have a civil court case would be something like Joe owes me $1,000 because he took my car and crashed it. And so the person saying that Joe owes him $1,000 has to prove that. But that's in a civil case. And so, I mean, for For us to have an easy way to remember that is, I suggest, and this is for the purpose of the exam, that you don't focus on criminal law or civil law, that you focus only on California employment law, which is very different than any law outside of the state of California. And that you sort of somewhat take the attitude that the burden of proof is always on the employer. There are instances when it's not. There's some, I'm trying to think of what it is, but it's certainly not harassment. Okay. I'm not sure why harassment is a tort, and a tort means that you're suing for damages that occurred, not that we're going to throw somebody in jail. So, it's fascinating. In California, you can only sue somebody for money. And in Texas, they can shoot you. No, not really. But they can, for sexual harassment, you can be put in jail for 6 months. And these are just for minor offenses. Now, we know for a fact, because we've seen it happen, that there are certain cases in California where people can be jailed for harassment, but they have to be very severe and pervasive. Let me go in there. I want to see what Kathy had to say on this. Kathy, what are you saying in here?
It's just defining the difference between the tort and civil action.
Oh, okay. And what is that?
Just exactly what you just said, that
Oh,
it's about damages. Yeah.
yeah. So please know that the employee does not have the burden of proof for a harassment claim. And I'm not sure why that person thought that they did. The employer has the burden of proof that it didn't happen, not that it did happen. And that's through, just think about everything we've seen on television. That's through a clear and concise investigation. Okay. All right. Next question.
Somebody is out of Texas, because in Texas, sexual harassment is actually a misdemeanor, but sometimes can be a felony.
Yeah, right?
Really different in California.
I know. Everybody thinks California law is so strict. There are some laws that Montana, Texas, they're severe. They're much more severe than what we have. Okay, Kathy, this is the one I was telling you I wanted you to jump in on because of your legislative experience. Please describe the difference between an assembly bill and a Senate bill. So it's kind of simple. If the author is a senator and the bill is introduced in the Senate, then you have a Senate bill. If the author is an assembly member and the bill is introduced in the assembly, then you have an assembly bill.
That's basically it.
So I guess maybe the question is, since she's not here tonight and we're going to answer this for her, maybe she doesn't know the difference between the assembly and the Senate.
Perhaps. And if she's talking about California, it's assembly and Senate. If she's talking about federal, it's House and Senate.
Right.
So like a House bill would be an HR, H.R. not human resources.
You said federal would be HR?
Yeah, so if it's a House bill, they usually do it as an HR bill number.
Oh, okay.
So it's House of Representatives bill number, blah, blah, blah.
And so like we had AB 1825, which was assembly bill regarding harassment. And then we had Senate Bill 1343, SB 1343, which is Senate Bill. They essentially say the exact same thing, but one was passed in the Senate, one was passed in the Assembly. Where does the legislatures come in here?
What do you mean?
So we have the legislative committee. Are they a part of the Senate or the Assembly?
Well, they're all considered the legislative body.
Oh, And you and California, and Kathy is kind of famous up there, by the way, because she's the one who goes up there and talks to them about anti-harassment training and what we should be doing. All right.
Maybe, I wonder if the question maybe was getting at like progression. Like if it's assembly bill, then that's at a lower level, right? And then if it
Right. And
goes to the Senate as the next course of progression.
well, and it could go to both. So I think that's the thing, is that she's not here to kind of expand on what she was asking, because if it's just simply what's the difference, then the answer that Jacqueline gave is the answer. But if she's asking what is the process, there are some things that the assembly, like appropriations committee, there's some things that they appropriate in assembly and some in Senate, just like, you know, in Washington. But there are other things that you'll see, like our House of Representatives, they start the process, but it has to go to the Senate for final approval. If both houses don't approve, then it doesn't go.
So then if it's a state issue, then it's starting out as an assembly bill, moves to Senate. If it's a federal type thing, it's starting out as HR bill and then becomes SB.
Not always, because sometimes even in California, the Senate can just start, a senator can start a bill. A senator could actually write it.
Mm.
And it could start in the Senate and then go to the assembly for committee hearing.
Oh.
Mm-hmm. Yeah, so it's that, so I'm not sure where she was kind of going with her question, but what Jacqueline said in the beginning, the difference between assembly and house is literally that they're two different houses.
Okay.
But they all work together.
Hopefully.
So there is a bill right now, a committee bill that both houses are involved in California, that could potentially expand the year requirement for when we have to get all the employee training done in harassment, to extend it one more year. Committee bills typically go pretty fast. This one's been sitting there, God knows why, but it's been sitting there since April. They usually go really fast. This one technically has been approved by both houses, and the committee is all good with it, except for they want to do a few little tweaks. So it's just like waiting for the tweaks, I guess, before they release it.
Interesting.
Yeah.
Okay.
So now I've told you all, next question.
Yeah, and Colleen's back, which is good because we're on her question now. Are there any restrictions on paying profit sharing as there are with commission, or is it at the owner's discretion what is paid to whom? The answer to that question is it depends on how your policy is written. And that's all there is to it. So if you have a policy that says that profit sharing, so, well, actually, that's not, I only am answering half the question. I got that one not exactly correct. If you have a policy that says profit sharing is at the owner's discretion, then it's at the owner's discretion. And the owner can say, you get $10, you get $5, you get $3, period. Commission, on the other hand, requires a contract. So you cannot pay an employee commission without a contract, but you can do profit sharing bonuses with nothing more than a policy.
Okay, so for instance, if we have, say you're a client service rep and the pool would typically be $1,500, but your attendance isn't good, your performance isn't up to par, you can adjust that accordingly?
Depending on,
as long as it says at their discretion?
Yep.
Okay.
Completely different with commission. However, if you have a commission plan for those people that say they're going to get 10% of what they brought in, that negates any discretionary privileges that an owner has.
Can you have a commission structure and a profit sharing structure?
Yeah, you can.
Okay.
an employee is on a 410 schedule and their designated schedule is Monday through Thursday, they work the following hours. Monday 10, Tuesday 10, Wednesday 4, Thursday 10, Friday 10. How should Friday be paid? No. No. I see this as 4 hours of overtime.
Yeah, because it's on the 40-hour work week by that point.
Yeah, so the minute you took them off of 4 days, you put them, so anytime an employer takes an employee off of their regularly scheduled alternative work week, they move back into the normal overtime. So this person would just be paid for 4 hours overtime.
Okay, we ought to get back to regular.
I'm lying. I'm so wrong. I'm so wrong. I am so wrong on this.
Does this depend on when the work week is, though?
No. Hold on. Yes, I'm completely incorrect here. You are correct. They would be paid because the employer they're off their 4 hour, they're off their 410 schedule. So they would be paid 2 hours for Monday, 2 hours for Tuesday, 2 hours for Thursday, 2 hours for Friday of overtime. Yeah. I don't see the double time in there. Let's see. Let me get out my handy dandy spreadsheet.
Well, although Jacqueline, they didn't really take them off the 410 unless that's consistent.
No,
So
it's not a consistent thing.
It could be that the person on Wednesday needed to leave early because they had a doctor's appointment. So they're still on their 410, but then the company needs somebody to come in on Friday. Just like if you worked Monday through Friday, they needed you to come in on Saturday.
Yeah, but they still have to pay them the 2 hours of overtime on Monday, Tuesday, Thursday, and Friday. So, because they are not working 4 days, they're working 5 days.
They're working 5 days, but are they working 5 days because everyone is working a longer schedule for that week, or because? So what I'm saying is if the person didn't work on Friday, they just would have been paid their 410. But maybe the company called, and so I guess we should actually ask Colleen. So the company calls you and says, hey, we need you to come work on Friday, we're down. That'd be just like calling a person who works Monday through Friday, come in on Saturday, we're down.
Right. The Wednesday would be for some, they don't have work to do. They did work for 4 hours and it rained or the wind was blowing too hard or something and caused them not to be able to. And my only thought on Friday, because it is the 5th day out of a scheduled work week, that's where I came up with the 2 double time possibly. Because typically if they worked 5 tens, Friday would be 8 and 2. 8 overtime and 2 double time.
Right.
Yeah, so I believe, and this is pretty cool because we have a bunch of HR pros here and we're all going to disagree on this. I believe the minute they go off of their 410 schedule, that puts them into a regular work schedule, which would then require 2 hours of overtime on Monday, 2 on Tuesday, 2 on Thursday, and 2 on Friday. So that would be 8 hours of overtime plus 4 hours of overtime. It'd be 12 hours of overtime. Why do you think there's 2 hours of double time? Where do you think that comes from?
Because Friday's not a regular, it's the 5th day of the week. And typically if they would have worked 10-hour shifts each day, Friday would be 8 hours of overtime and 2 hours of double time, if I'm correct.
Well, they only worked 44 hours. So I don't see any double time in there. Kathy, are you madly out on the internet trying to get the answer to this?
I am.
Okay, good. Because, yeah, what I'm thinking is, what I believe is, even if you're on an alternative work week schedule, when you change, not change that schedule permanently, but you just go outside of the schedule, that puts them back into regular employment hours. So there would just be Monday, Tuesday, Thursday, and Friday would be the overtime after 8 in one day. And then there's a total of 44. 1, 2, 3, 4, 5. No, that would just be 8 overtime and 40 regular time. 2, 4, 6, 8.
Okay, I see what you. I
Yeah.
run into this a lot.
Yeah. We were on an alternative work week. I was even on an alternative work week. But we never, ever worked Fridays under any circumstances that I know of. They may have paid me right and I didn't know it, or they may have paid me wrong and I didn't know it. So, all right, we'll let Kathy continue to look on that. Let's see if we have any more questions. Okay. On FA 14.1, paid time off and other important payrolls, pre-recorded lecture, it stated that deductions can be taken from employees' paychecks for reimbursement of overpayment of wages. I know that an employee must sign a statement saying that they are aware and accept the deductions, but what if the employee refuses to allow any deductions or pay any overpayment back? What if the employee states that it was the employer's fault and therefore they should not be punished for a mistake that wasn't their own? Can an employer still deduct? Technically, no. It happens, but without the approval. So here's what I do. And I've been doing it for years, and this is completely legal. When I sign them up for their automatic bank, automatic banking, there's a statement in there that says if I accidentally pay you any money, you're authorizing me by signing this document that I can take it out. Okay. So if you have that kind of a statement in your direct deposit form, then they can take it out. But everything's got to be signed and in writing. If they refuse to, I remember there's this gal who she broke she had $1,000 Mac, and she was mad, and she threw it on the floor and broke it. Okay, and so my employer wanted to deduct that from her wages. And she said, absolutely not. And so we called the labor law attorney and he said, absolutely not. So Urjana has the case. Tell us about it, Urjana.
Yeah, so basically I'm dealing with this, this was my morning today, where one of our managers was accidentally, she was out on FMLA, and someone added her normal work schedule to her workforce, which is our payroll company. And so she ended up getting paid for a week while she was out on FMLA. She returned the week after, and we verified that she did not do any work during that time. However, those hours were already added, and we don't have anything that basically says we can take back overpaid wages. So we just kind of have to eat the cost of that.
Did you ask her to give it back to you?
Not yet, no. I'm going to do that tomorrow. But realistically, being out on FMLA, she's not going to.
Yeah, no, I know.
Yeah, that's her.
That happened to my husband, and we were honest. We did pay him back, but before we paid him back, they took all of his next paycheck. So he went to work for 2 weeks and he got a 0 check for 2 weeks. And I, as the consummate HR professional that I am, sent them a slamming letter telling them that the law does not allow them to do that and that they needed to ask us. And in any case, they could never take more than 25% of his entire pay anyway. And I just went on and on and on and on. And it was pretty good because they then put all the money back in his account and then we made payments. They put all the money back in his account and then we turned around and wrote him a check because it was sort of just the point for them. But yeah, anyway, so that's one of my stories. All right, thanks, Regina. I'm sorry you're dealing with that today. All right. Did we answer your question, Catherine?
You did. Thank you.
You're welcome. All right, comp time, makeup time. Does an employer have a legal obligation to approve makeup time if requested by a non-exempt hourly employee if there is no business need? Yeah, but the employee has to request it in writing and the employer has to respond to it in writing. And there's all kinds of little forms all over the internet that you can get. California makeup.
Is this dependent on industry? Because, so let's say we schedule an employee for 30 hours, 35 hours. They call out of 2 of their shifts, and then they request makeup time for those 2 shifts. And we don't have any availability because we don't have any business needs. We already have other people scheduled. Now, do we have to, we already called people in to cover for that employee for the 2 hours. Do then that impacts us negatively? Would we still have to comply?
So we're talking about 2 completely different things. So I don't know what you're talking about, but what you're talking about is not required. Makeup time is a law that says an employee has to ask in advance for the time off, preferably 30 days in advance. They can't just call you and ask for makeup time. What the heck is that? Sick pay? Can you explain that?
Maybe I misunderstood the concept of makeup time then, because
I think you do.
Yeah. Okay. Then that makes more sense.
Yeah, so check this out. This is a makeup time form from San Diego State University. So you figure it's probably pretty spot on. And it says, I'm requesting time off as a result of a personal obligation. So makeup time is designed for the employee who knows that they're going to need to take 4 hours off on Friday, and they don't want to lose their weekly wage. And so they're going to come in on Saturday and work for 4 hours and not get paid overtime. That's makeup time.
Okay. Yeah, I think I just misunderstood the concept of makeup time, that it needs to be requested in advance when you're not going to be able to make a shift or apply.
Yeah, and it has to be made up like within the first week, within the pay period, I think it is. And it has to be done in writing. It has to be approved in writing. And yeah, it's a pretty neat little thing, but it's not, employees can't just randomly ask for makeup time. That's like saying we're going to randomly ask for PFL, paid family leave. There's no paid family leave. That's a wage replacement program. All right. That's another class though, isn't it? Okay.
Okay, so you want the answer on the alternative?
Yes.
So here's where the difference is. It says, if an employer whose employees have adopted an alternative workweek agreement permitted by this order requires an employee to work fewer hours than those that are regularly scheduled by the agreement, the employer shall pay the employee overtime compensation at the rate of 1 1/2 times the employee's regular rate of pay for all hours worked in excess of 8 hours, and double the employee's regular rate of pay for all hours worked in excess of 12. But it's saying that it's at the employer's request. Her example was that the employee didn't work the other 4 hours. But nowhere on here, on any of this stuff, does it say anything about that the other days change that alternative work schedule unless it's by the employer's request. So her question is great, except for that we don't know who requested that change. So if it's by the employer's request, then I would say your calculation was right, Jacqueline, that then it would go to the 8 hour, 8 hour, 8 hour.
Yeah.
And 8 hours of overtime every day. But if the employee was just saying, I'm not going to work, you know, because I'm going to be gone, then it doesn't change it. So I think she had said that the employer said, we don't have enough work for you on Wednesday. If that's the case, then the employer changed the agreement and you would have to pay as if it's an 8 hour day.
Yeah.
And that's not just for that specific day, that's for the entire week. The entire week then
Yeah,
changes?
it would shift the entire week is what they're saying.
Yes.
Okay.
All right. States can deduct in full day or intermittent basis case study. You have an exempt employee that's returned from FMLA fully cleared. This employee has exhausted all sick and vacation time. Employee works typically 5 days, but calls out for 2 days, stating the reason for the call out, a medical condition related to their previous leave. Can you deduct those 2 days and only pay them for the 3 days missed? So here's something I want you guys to start using, and it's called language. All right. So you cannot deduct the 2 days, but you can designate. All righty. You can designate those 2 days to the leave and only pay for 3 days. Or exempt employee goes out on FMLA on a Wednesday for 4 weeks. They worked Monday and Tuesday of that week. They have no sick or vacation time available to use. Do you pay the whole week based on the exempt status, or can you pay only the days worked? Once again, we had talked about coming in and going out. Well, that applies to leave as well. So if their leave starts on Wednesday, then you only pay them for the 2 days, and then they begin their leave on Wednesday. Oops, look at that. I didn't know I could do that. All right. I'm so weird, I know. All righty. So look at this, 7:37, and we did it. We got through everything. Okay. Super. So I will talk to y'all next week. I'll hang around if anybody has any more questions.
What was the document? I think it had columns of numbers on it. I just saw part of it. I don't know if you or Kathy were showing it.
Oh, if you scroll up, you'll see the link. Scroll up in the chat. And it says California Labor Commissioner's Office Report. And just click on the link.
How far up do I go?
Not very far.
Very far?
No, not very far.
Oh. And I probably passed it a long time ago.
Here, I'll post it again.
So when you're posting something, it's going over in the chat area?
Yeah.
And then how do we get it?
Just click on it.
And then it downloads?
Yeah. There, I just stuck it on there again.
So it should be at the bottom?
Yep. Scroll all the way down to the bottom of the chat.
It doesn't act like it will download.
Just copy it and then put it in your browser.
Oh, okay.
Yeah.
All right, so that's that one. And then, let's see. Jacqueline, you had mentioned this was not this time around, but before, there was some, when you were encouraging us to be connected to some labor reports or whatever, there was one that you seemed to have a particular preference for.
Anthony Zoller.
I don't know if you had put it up or not, and I wouldn't know how to get it if you did. So
Let's see. So Anthony, Zallr. I'm going to look it up for you, and then I'm going to actually give you the link. Is it Zoller or Waller? Oh, there we go. Anthony Zoller, Esquire. All right. And there's a cute little picture of him here. He's a young kid, but I really like his reports that he sends out.
mm-hmm.
So if we go on here, and what I'd like for you guys to do is go on here and get on his newsletter. So let's see. Kristen, do you want me to put you on as an experiment?
Sure, that'd be great. Thank you.
Let's see. Make sure I have your right email address. Of course I don't.
It should be let's see, KP
Oh yeah, that's right.
watching it young.
Yeah, so then I click subscribe, and then he'll send you something like a confirmation email, and then you'll just have to say yes, I do want to receive your emails, and they're really good. Sometimes he does videos, and sometimes he just does voice. So yeah.
All right. And then I had some sound issues last week where I lost all the sound. So I got out of Moodle School and then I got back in. So then I could hear what you were saying, but I had missed the discussion about the